Can you hear me now? All right. We have just one hearing on the agenda today. And let me just pull. All right. My name is Monica Schmucker. I'll be the special magistrate for today's hearing. I do ask that if anybody does have a cell phone, that you please silence that now. Do you have the agenda there with you, or it's not pulling up? I'm sorry? Absolutely. Yes, go ahead. No, that's fine. Thank you. Okay. Good? All right. So we have lien foreclosure case of White Sand Property of Fort Myers Beach LLC. Authorization to foreclose lien, FMB case number CE 140394. Property address 80 Avenue E, Fort Myers Beach, Florida. Who do we have here for the town?
Chloe Berryman, Assistant Town Attorney.
Thank you.
Nancy Stuperich, Town Attorney.
Thank you. Respondent?
Good morning, Alex Brockmeyer and Steve Ramoni.
Thank you.
Good morning.
Good morning. All right. Sorry, I'm just pulling up. There are quite a bit of the agenda items, which I did review, so all right, so this will be a quasi-judicial hearing, which means similar to a case in court. As a reminder, the rules of evidence do not apply, but fundamental due process will apply. After the hearing, I will issue an order with findings of facts, conclusions of law, and any any relief awarded. I will do so either today or within 15 days of today's hearing. Anybody who's going to be providing testimony, I do ask that they stand at this time for the oath. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay. All right. In town, may proceed.
And Your Honor, before I begin, I have printed out the exhibits, and I'd like to provide a copy.
The binder
to
of
you.
exhibits that were put online?
Yes.
Sure,
I'd like to provide a copy to you as well as the respondents.
sure. Thank you. Have you reviewed these, counsel?
Without going through it, I'm sure at one point we probably looked at most of what's in here between our circuit court case and this.
Okay,
We're fine to proceed. I'm not going to hold us up on that.
okay, all
Your
right,
Honor, a link was emailed to them.
Yeah.
right.
Prior to the hearing, and a link had been provided prior to each of the other notices of hearing.
Right.
I do have one question, though. We've had prior hearings,
Yes.
and we've submitted exhibits with those hearings. Is that going to all be part of this collective case record, or,
Well, for today's hearing,
I mean, it's all like part of the same case, right? So is it not building off that?
if it's been submitted under case number 14, CE 140394, then it'd be a part of the case record for that, but not a part of the case record of today's hearing unless you submit it today.
Okay,
Does that answer the question?
it does.
Okay. Do you have any objections to any of the exhibits? No. Okay, thank you. No?
No.
Thank you. Okay, you may proceed.
Thank you, Your Honor. Good morning. We're here today on the town's request for authorization to foreclose a code enforcement lien on the property located at 80 Avenue E under code enforcement case number. Is it on now? Okay.
Now it's on.
Code enforcement case number 14-0394. This code enforcement lien arises from a violation on the property that dates back to 2014. Respondent's predecessor in title was found in violation of the town code in order to bring the property into compliance within a set time frame, but failed to do so. As a result, a daily fine of $250 per day accrued, and a lien for the fine was recorded against the subject property. By 2019, the property had a new owner, Mr. Orlandini, who's also respondent's predecessor in interest, and the property remained in violation. Because the violation continued on the property, the special magistrate entered a code enforcement order certifying that a fine of $257,150 had accrued and continued to accrue in the amount of $250 per day for each day the property remained out of compliance. And this instrument was the code enforcement order imposing lien, which was recorded as lien against the subject property and all other real and personal property owned by Mr. Orlandini. And this was on March 27th, 2019, and it was recorded as the instrument number ending in 7137. This order is attached as Exhibit A to the notice of hearing, and it's also Exhibit 19 in the agenda materials. And this is the instrument that we are seeking to foreclose today. Section 162.09 sub 3 provides that the town attorney may obtain authorization to foreclose after 3 months from the filing of any lien that remains unpaid. Here, it has been more than 3 months since the lien was recorded on March 27th, 2019, and the town will present evidence that the amount of the lien remains unpaid. And I had a PowerPoint presentation. I don't know if that's okay. So the subject property, again, is 80 Avenue E. The property appraiser information on the screen shows that the property is owned by White Sand Properties of Fort Myers Beach with a mailing address of 415 Palermo Circle. The Sunbiz records for respondent list Mr. Stephen Ramoni as the respondent's registered agent and Jesse Schmid and Jody Hannon as the authorized persons for the respondent. And copies of respondent's Sunbiz records are also in the binder as Exhibit 3B for 2020 and 3C for 2025. And this is just in there to show that these were the authorized persons at all times relevant to the proceedings.
I have a quick question. Is the binder identical to the tabs that are in the
Yes, Your
online?
Honor.
Okay, thank you.
As you know, this hearing was rescheduled many times, 4 times. So Composite Exhibit 2 contains the notices for those other hearings and the documentation that they were rescheduled, and I included those just for the record. Exhibit 3A is an affidavit of notice and posting by T. Hoffman, a code enforcement officer for the town, attesting that notice was properly provided to the respondent for the hearing that was most recently rescheduled, and that hearing was originally set to occur on December 5th, 2025. Composite Exhibit 1 is the respondent's request to continue the December 2025 hearing and the magistrate's resulting order in e-service showing that the respondent expressly waived further notice of the hearing. And it also shows that respondent received notice of today's hearing date because the order rescheduling the hearing was served to the same emails from which respondent's counsel requested the continuance. And then Exhibit 3D is another affidavit of notice sworn and attested to by Thomas Yazzo, the Emergency Services Director and Code Enforcement Officer, showing that although the respondent waived further notice requirements for this hearing, the town still mailed a notice of hearing for today's hearing date with the lien we're seeking to foreclose attached, as well as a copy of the order of continuance, and that notice of hearing was mailed to the respondent. And all of this is being offered to show that proper notice of this hearing was provided and reflected on those notices of hearings for each hearing date. And the exhibits in this hearing were posted on the town's website approximately 1 week before each hearing date for each hearing. The only exhibits that have been added since July 2025 are Exhibits 1 through 3, relating to the history of rescheduling this hearing, and then Exhibits 4, 52, and 53, which were listed on the exhibit list provided on July 2nd, but the completed documents hadn't yet been provided at that time that the hearing was rescheduled. Therefore, the town has gone to great lengths to ensure that the respondent has had more than adequate notice of this hearing, and respondents have had the majority of the documents the town will be presenting for over 6 months. The lien at issue in this case is the result of prolonged noncompliance. An order imposing lien was originally entered on March 30th, 2016, during the ownership of one of respondents' predecessors in interest, and that order imposed a fine of $250 per day, beginning on March 25th, 2016, and continuing to accrue each day the violation on the property continued to exist. And this order was recorded April 12th, 2016, as instrument number 2016-0000-76125, and this is marked as Exhibit 13 in the binder. And that's also represented by the first bullet point in the PowerPoint. Next, a subsequent order certifying the lien was entered on March 22nd, 2019. This order found that the owner of the property at the time had not complied with the previous order and had not paid the fine, which at that point had accrued to $257,150 and continued to accrue at $250 per day. Ultimately, this order vacated the previous order imposing lien and certified that a fine in the amount of $257,150 had accrued and continued to accrue at $250 per day for each day the property remained out of compliance. This order was recorded March 27th, 2019, again as the instrument number ending in 7137. And again, this is the instrument the town seeks to foreclose today. That's Exhibit 19. After that, the property still remained out of compliance, and on April 16th, 2024, an affidavit of compliance was issued in this case, finding that the subject property had come into compliance on September 28th, 2022, due to Hurricane Ian and the subject property being demolished. And this affidavit of compliance is Exhibit 45A in the binder. Get up the bank here. And you can see on the face of that affidavit, it is attested to by Thomas Yazzo, the code enforcement manager at the time for the town. And then paragraph 4 of the affidavit of compliance Tom states, according to available records in possession of the town of Fort Myers Beach, a desk inspection of the subject property was performed by a code enforcement officer on the 4th day of April 2024, and the subject property was found in compliance on the 28th day of September 2022 due to Hurricane Ian and the property being demoed. And then skipping down to paragraph 6, Mr. Yazzo testifies, code enforcement case number CE 14-0394 will be closed upon payment of $594,650 lien in full. And this compliance date determines the total amount of the fine. So pursuant to the order constituting the lien that we're seeking authorization to foreclose, again, $257,150 had already accrued as of January 17th, 2019. This continued to accrue at $250 per day until the property was brought into compliance on September 28th, 2022, as indicated in Exhibit 45A. And so between January 17th, 2019 and September 28th, 2022, this is an additional 1,350 days. At $250 per day, this amounts to an additional $337,500 that continued to accrue under the lien, which amounts to a grand total of $594,650, and that is the amount owed under the lien. This total is consistent with the affidavit of compliance in this case, which again is Exhibit 45A. The statutory prerequisites for foreclosure of a code enforcement lien are set forth in Section 162.09 sub 3, which provides after 3 months from the filing of any such lien which remains unpaid, the Code Enforcement Board may authorize the local governing body attorney to foreclose on the lien or to sue to recover a money judgment for the amount of the lien plus accrued interest. As indicated by the clerk's stamp on the face of the lien marked as Exhibit A, the lien the town seeks to foreclose was recorded in the Lee County Public Records more than 3 months ago. And the lien also remains unpaid, which again is evidenced by Exhibit 45A, the affidavit of compliance confirming that a total of $594,650 is due under the lien. And then more recently, we also have an affidavit of code enforcement manager, which is Exhibit 4. And that is signed and attested to again by Thomas Yazzo. And again, Mr. Yazzo's not here today, but the relevant portion of that affidavit is paragraph 16, which states fines accrued between March 25th, 2016 and September 20th, 2022 for the violation in the amount of $250 per day for 2,378 days, equaling a total of $594,500 plus $150 in administrative fees for a total amount of $594,650 due under the lien in the instant code enforcement case. Paragraph 17 says the current status of Code Enforcement Case 14-0394 is lien recorded. And then the final paragraph, paragraph 18, states that the instant code enforcement case will be closed upon payment in full of the $594,650 due under the lien in the instant case. And you can see that this is sworn and attested to by Thomas Yazzo, Emergency Services Director for the town. And so what you've seen so far is evidence sufficient to demonstrate that it would be appropriate to authorize foreclosure on the lien marked as Exhibit 19 because it's been 3 months since the filing of the lien and the lien remains unpaid. However, over the last couple of years, the respondent has attempted to contest the fact that the lien remains unpaid by claiming the existence of some sort of agreement with the town, and the town's position is that no such agreement exists. So if the respondent is planning again to claim that this lien has been satisfied or greatly reduced, or that nothing is owed by virtue of some agreement, I'm prepared to present the remainder of the documents in this binder in chronological order alongside a timeline I prepared, which is Exhibit 6, based on these documents and presented as a summary of these documents, which are numerous. Ultimately, what these documents will show is that White Sand acquired the subject property with knowledge of the lien we're seeking to foreclose. From the time White Sand acquired the property, the town staff attempted to work with respondent to settle the code enforcement issues on the property. However, the town couldn't settle the matter until the violation on the property causing this lien to continue accruing had been brought into compliance, and that never happened. And so ultimately, the respondent refused to correct the issues on the property, and it remained out of compliance until it was demolished by Hurricane Ian, and the liens and the fines under the lien continued accruing up until that point. So I can either present these documents to you now to further prove that the lien is ripe for authorization to foreclose because it remains unpaid. I would prefer to present them in response to any claim that Respondents' Counsel raises, just to be able to tailor my response and save everybody a little bit of time. So I would just ask that I reserve on my ability to do that pending their claim of any sort of agreement.
That'd be fine. In your reply, you absolutely can
Thank you, Your
reply to
Honor.
whatever their response is.
Okay. So in that case, I just want to reiterate that what we're here for today is simple. We're requesting authorization to foreclose the lien that's recorded as instrument number 2019-0000-67137 in Code Enforcement Case 14-0394, which again has been marked as Exhibit 19. Again, it's clear on the face of the lien that it's been more than 3 months since this lien was recorded, since it was recorded on March 27th, 2019. We are now in 2026. And it's also clear that the lien remains unpaid, as evidenced by the Affidavit of Compliance marked as Exhibit 45A and the Affidavit of Code Enforcement Manager marked as Exhibit 4, both of which show that the amount due under the lien is $564,650 and that this amount has not been paid. Accordingly, the evidence shows that the statutory prerequisites set forth in Section 162.09 sub 3 have been met, and the town respectfully requests that Your Honor enter an order authorizing the town attorney to foreclose the code enforcement lien marked as Exhibit 19. Thank you, Your Honor.
Thank you. Response?
Good morning. As again, I'm Alex Rothmeyer, and I have with me Steve Ramone. What I'd like to do first is actually kind of recap how it was we got here. And I know Your Honors presided over all this, so you're very familiar. But what we have is a situation where, as Your Honor may recall, the town initially sought to foreclose, in this case, instrument number 2016-0000-76125, which is the town's exhibit, let's see here, in this list, 13. That was the first order imposing lien. And as Your Honor is well aware, as we discussed at our last hearing, the town asked Your Honor to give it authorization to foreclose on that lien. And on February 12th of 2024, in this case, you granted that permission and authorized the town to foreclose on that instrument number, which just, again, Town's Exhibit 13, I'm going to shorthand the instrument, ending in 76125. Your Honor's foreclosure authorization order is the town's Exhibit 47. Now, as Your Honor will recall, and I can present it to everyone here. I'm going to mark it as Respondents Exhibit 1. Show you a copy. It's what you guys presented at the original hearing.
I have a copy of it.
Okay. Can I approach? So as Your Honor will recall, at that hearing, and the town did not introduce any evidence whatsoever of an intent to foreclose on the lien that we are now here about today, that they're seeking to foreclose on, which is the instrument number 2019-000067-137. And Your Honor had entered an order on, I believe it was February 12th, so almost a year ago, of last year, where Your Honor made clear at that prior initial February 2024 hearing, the town was always focused on this 2016 instrument. That's Exhibit B2 of our Exhibit 1, the town's 13, the instrument ending in 76125. And I can mark, since we don't technically have everything continuing to accrue, this as Exhibit 2. You need to see the order that's already entered.
Yeah, okay, thank you.
Your Honor, in that order made quite clear, there was no clerical error. There was no ever introduction of this 2019 lien ending in 67137. Everything was about the 2016 instrument number ending in 76125. And more importantly, that the town never requested authorization to foreclose on the lien we're here about now, the one that ends in 67137, which is, again, the town's Exhibit 19. And the reason that's all important is because, as Your Honor has noted, the lien that the town initially sought to foreclose on, that they got the authorization to foreclose on, that instrument 76125, that lien was vacated. So when they got that foreclosure authorization letter, that foreclosure authorization letter or order was a final order. Your Honor's order makes clear it could be appealed. The town didn't appeal that. So that foreclosure authorization order gave the parties finality in this case as to what lien could or could not be foreclosed upon. And so what we have then is the town elected a remedy. We had two different liens. They elected to foreclose on the one bearing instrument number 2016-0000-76125, not the one they're now trying to foreclose on. Now, I understand that 2016 instrument number was vacated, but that doesn't matter. Under Florida law, and I can provide everyone with a copy of this case, it's a 3rd District Court of Appeal decision. Approach, Your Honor. We're going to be looking at page 7 of the order. In there, it talks about election of remedies. And in there, the quote from this 3rd District Court of Appeal decision from 2024, which is North Bay Green Investments, LLC versus Cold Pressed Raw Holdings, LLC, 388 Southern 3rd, 266. It says, a plaintiff is not guaranteed success in the choice of remedies. only an opportunity to proceed under a theory which has been pled. Thus, in Florida, an election is binding and irrevocable even under circumstances where the chosen remedy is improper or non-existent. So what we have here is a situation where the town elected its remedy. It said, we want to foreclose on this 2016 code enforcement lien, even though it had been vacated. But the third district has said, and you see it cites a number of authorities there, all very recent, that doesn't matter. That decision is binding on them in this case. Even if the lien they asked you to authorize foreclosure on had been vacated. But they're now stuck with that decision. They've elected their remedy. They don't get a second bite at the apple. So the foreclosure request is invalid. It should be denied. They're not authorized to foreclose on it because they've already elected that remedy. And they're stuck, and it's binding on them. It's irrevocable. And that's because that foreclosure authorization letter is a final, foreclosure authorization order is a final order. And we know that because one of the cases, as Your Honor knows, we've been embroiled with the town on a number of circuit court litigation. One of the cases the town has taken to citing quite frequently is a case called Kirby versus City of Archer. Here's your Kirby case. Your Honor, approach. When we go there, it talks about a code enforcement hearing board and this sort of quasi-judicial status that we are sitting in now and that we were sitting in back when the foreclosure authorization order was entered. And it says matters determined in an order which have become final without appeal are not subject to any sort of review, and they're not also subject to any sort of collateral attack. It's a res judicata collateral estoppel issue. And that's exactly the position the town has taken in these circuit court cases, is that under Kirby, Your Honor's prior orders, including the foreclosure authorization order, acts as a res judicata. It is a final order. And so if it's final enough to have an effect of res judicata or collateral estoppel, so too is it final enough to constitute an election of remedies by the town, which again, under the North Bay case, makes clear then that the town is not authorized to foreclose on this lien because this case is at a conclusion with that final foreclosure authorization letter. And so in that aspect, we would ask Your Honor to deny the foreclosure authorization hearing today. I do have an affidavit from Mr. Schmidt that I'm gonna introduce. There is nothing in this affidavit that's different from what Mr. Schmidt testified at our prior hearing, but just for the sake of, I guess, having it for the court and developing the record, it's in a binder because it's kind of large. I'm gonna introduce it, but other than that, that would be the extent of our presentation this morning. So if I can approach, I'm gonna give them a copy as well. Do you want this on the outside or the inside? And consistent with what we argued to Your Honor back in, January of last year, it's our contention that the contents of Mr. Schmidt's affidavit shows that this lien was resolved by everyone through that agreement between Mr. Orlandini, Mr. Schmidt, and the then town manager, Roger Hernstad. One of the things, though, that I want to note is...
Sorry to interrupt you for a
Uh-huh.
second, but I just want to give council the opportunity to review the exhibits and state whether there's any objection.
Oh,
'cause-
okay.
Thank you, Your Honor.
yeah.
No, Your Honor, I have no objection.
Okay, thank you. You're seeking to admit them.
Yes, Your Honor.
Okay.
So one of the things, though, that I want to touch upon was, and this is even in the town's Exhibit 23, I believe it's 23A. There is a partial release in this case, in Code Enforcement Case 14-0394, that reflects a partial release accounting for the $50,000 that was paid towards these liens. That amount, from what I've been able to ascertain, has not been accounted for in this total amount that the town is seeking authorization to foreclose upon. And so we need to have that accounted for. If you account for that lien amount and a reduction for the $50,000 that's been released, that would make the lien $544,650. And then there is the letter from Carl Bengay, which is in the affidavit. It's in the town's exhibits as well, which is essentially stating that as of November 18th, 2020, there were no active code enforcement cases against White Stand as it relates to 80 Avenue E. I think that's important because regardless of whether you want to agree with us or not that there was a settlement, we think that that letter shows that at a minimum, at that time, this property was in compliance with all the code violations that were against it, which means that if you take the $250 a day and you run it from March 25th, 2016 to the date of that letter, November 18th, 2020, that's 1,699 days. At $250, that's $424,750. And then if you again account for the reduction of 50,000, that gets you $374,750. So no matter what the outcome is of this settlement agreement, whether you agree with it or not, the lien amount the town's seeking authorization to foreclose upon is incorrect. It should at least account for the $50,000 set-off, which would put it at, again, $544,650. And if you agree with our position that Mr. Bengay's letter shows that there was no code violations existing as of that time, then when you take that math, run it at $250 a day at $1,699, and you account for the $50,000 payment, the amount would be $374,750. And so with that, we would rest our presentation. Thank you.
Can you direct me to the letter?
Huh?
Can you direct me to the letter, please?
That is going to be your tab, E of the affidavit from Mr. Schmidt. And you'll see there at the very bottom, sorry, I got to get to the microphone. The very bottom of the first page, it says there are no active code enforcement cases on this property, and it's with regard to 80 Avenue E, which is the subject property.
Okay, thank you.
Yes, Your Honor.
And Your Honor,
Okay.
before I respond, if I could just have a few moments to review this affidavit representing Mr. Schmidt's testimony. This is the first time I'm seeing it.
Sure. Do we want to take just a quick break?
Yes, Your Honor, 10 minutes.
10 minutes? Okay. Okay, we are back. Did you have the opportunity to review?
Yes, Your Honor.
Okay, all right, we may proceed.
Thank you, Your Honor. Is this on? Okay. So first I want to address respondent's theory. Respondent's theory that because Your Honor previously authorized foreclosure of the lien recorded in 2016, that the town is now precluded from seeking authorization to foreclose the 2019 lien. This argument fails for a number of reasons. The most simple being that the prior order authorizing foreclosure addressed a completely different instrument than the one before you today. The case that they're citing, North Bay, deals with different causes of action. This is not a different cause of action. This is an entirely different instrument. We're requesting to have authorization to foreclose this particular instrument. Last time we're requesting authorization to foreclose a different instrument. The lien before you today was not at the 2024 hearing. It was not in the notice for the hearing. It wasn't included or introduced to that hearing. It didn't appear in the order. That's because the instruments are different. The cause of action is different. The lien we're seeking to foreclose today reflects a distinct legal basis for foreclosure separate from the vacated 2016 lien, and it's not barred by prior authorization. Chapter 162 explicitly ties the ability to obtain authorization to foreclose to the recording date of the individual lien at issue. Under Section 162.09 Florida statutes, the foreclosure authorization turns on whether that particular recorded lien remains unpaid 3 months after its filing. The statutory trigger to be able to foreclose after 3 months from the filing of any such lien which remains unpaid is particular to the lien, which means that each lien ripens individually. The facts the town must establish for authorization to foreclose the lien before you today are that the lien was filed on, in this case, March 27th, 2019, and that the lien remains unpaid 3 months after March 27th, 2019. This is a completely different set of operative facts from the 2016 lien. The elements in the statute attached to the particular lien, so prior authorization referencing a different instrument, does not adjudicate whether those elements have been met for the lien before you today. I also want to note that the case that they cite, North Bay, deals with a completely different factual scenario. It doesn't deal with lien foreclosure. It doesn't deal with quasi-judicial code enforcement proceedings. More analogously, Florida's foreclosure cases clarify that res judicata does not bar subsequent or successive foreclosure action when they arise from different operative facts. The Florida Supreme Court held that the doctrine of res judicata does not necessarily bar successive foreclosure suits because a foreclosure predicated upon a subsequent and different default presents a separate and distinct issue. And that's even if a prior foreclosure action on the same instrument, the exact same instrument even, was adjudicated on the merits. And I have a copy of that case, that's Singleton v. Graymar Associates, that I can provide to everybody. Florida courts have emphasized that foreclosure is an equitable remedy and res judicata should not be applied so strictly as to prevent the enforcement of valid liens to work an injustice. And that's what that case that I just gave you represents. I have another case on the same proposition, which is 2010-3 SFR Venture LLC v. Garcia, which I can provide you in a moment, as well as Hayes v. Reverse Mortgage Solutions Incorporated. And then I have another case, Bartram v. U.S. Bank, and in that case, the court explained that if subsequent foreclosure actions were barred, the mortgager would have no incentive to make future timely payments, and clearly justice would not be served. Applying res judicata to bar authorization to foreclose the correct lien would frustrate the statute's purpose and enforcement scheme, and it would produce the same kind of inequitable results as these cases represent. It's also important to consider the fact that in this hearing, as well as previous foreclosure authorization proceedings, these are all quasi-judicial administrative hearings under Chapter 162, and the Florida Supreme Court has warned that the principles of res judicata do not always neatly fit within the scope of the administrative proceedings, and that res judicata is applied with great caution in administrative cases. And the case that I have on that point is Thompson v. Department of Environmental Regulation. So I'll give you that case as well.
While you pull that, you mentioned Hayes and another case after that. I'm not sure if you have copies of that, but if not, could you provide the citations?
Yes, Your Honor. I do have a copy of Hayes. I will give you that as well. The other one was SFR Venture LLC v. Garcia, and then Bartram v. US Bank.
I didn't get that, so just when you go back to the podium, just so I can think.
And so those cases, again, were Bartram v. US Bank, 2016 Florida Supreme Court case for the proposition that if subsequent foreclosure actions were barred, the mortgagor would have no incentive to make future timely payments, and clearly justice would not be served. Similarly, on those points, there's SFR Venture LLC v. Garcia, Hayes v. Reverse Mortgage Solutions, Inc., and then I also provided Thompson v. Department of Environmental Regulation for the proposition that principles of res judicata do not always neatly fit within the scope of administrative proceedings, and that res judicata is applied with great caution in administrative cases. Returning to Thompson, in issuing this caution, the court recognized that the administrative setting often deals with fluid facts and shifting policies, and notes that the finality of unappealed judgments of courts is ordinarily well understood in advance, whereas statutory provisions often implicitly deny finality or fail to make clear whether or when administrative action should be considered binding. This warning is appropriate for our procedural posture here and the factual record, because we're not relitigating a 2016 instrument. We're seeking to foreclose a later and operative lien. And under these circumstances, applying res judicata to bar consideration of the correct lien would elevate a clerical mistake over the intent and purpose of Chapter 162. So for all of these foregoing reasons, in this case, the prior authorization to foreclose the lien recorded in 2016 does not preclude our current request to foreclose the lien recorded in 2019. Again, this lien represents a new independent cause of action because it's based on a subsequent order certifying accrued fines and replacing the earlier lien. So as to that argument, the town respectfully requests that Your Honor determine that the town's request is not barred, and that Your Honor hear the town's request to foreclose this instrument on the merits. And then I'll just address the claims that respondent made as to the rest of the case. Jason, if you could bring my PowerPoint back up. I'm going to present some of this timeline, but I'm going to just focus on the parts that have to do with what the respondent raised. And respondent claims that on December 9th, 2019, he went to town council to request that he be able to pay to settle a number of liens on the property, and the property being 80 Avenue E. And the minutes from that town council meeting reflect that that is not what happened. So the minutes from that meeting reflect that Jesse Schmid stated he was buying a house with lien issues and pledged to pay $50,000 toward the liens. Joe Orlandini, resident, indicated that Mr. Schmid was purchasing one of his homes, and he explained the umbrella lien situation. Mr. Orlandini noted that selling the property would help remove some debt. And Mr. Schmid's request concerning satisfying part of the lien for the property and the umbrella was brought up. The town manager indicated they could craft an agreement for them to proceed on that one particular property, and the council members agreed with the action. And I think the video for that meeting really speaks louder than I can to it, so I'm going to play that video if I can. Can we click on that first one? The link should have automatically queued to when Jesse Schmid came up for a public comment. Do we have sound? while we're waiting, I'll just elaborate on what this video is going to show. So paragraph 5 of the respondent's affidavit states, on December 9th, 2019, I, on behalf of White Sand and Mr. Orlandini, approached the town of Fort Myers Beach, Florida, about resolving the liens in code enforcement case number CE 0167, CE 0394, and CE 17-0065 that encumbered the following properties as a result of code violations committed at 80 Avenue E, and it lists several properties, including 1710 to 1740 Estero Beach Boulevard, 1560 I Street, 80 Avenue E, and then a couple of other legal descriptions. And he claims that at this meeting, White Sand and Orlandini offered to pay the town $65,000 in exchange for the town agreeing to settle all the liens associated with 80 Avenue E and release the properties owned by Orlandini from the liens. It says, they say that at this meeting, the town authorized its manager to resolve the liens.
Okay, just give it, are you gonna be able to get the volume up on that?
Is it working now, Jason?
I mean, I'm willing to to give him a minute if he needs a minute to pull up the audio.
Okay.
I have it on my computer. I could do my audio on my computer and use the mic. I don't know.
I don't have the
Times
times written down.
Because I can do it on my computer and just put a mic on it.
I have no objection if Your Honor wants to watch the video, if you're going to reserve anyway, or after today's hearing. I mean, it's on YouTube. I've seen it.
Okay, do you want to take like a 2-minute recess to figure that out, or do you want to play your computer?
I think, Your Honor, I was able to bring it up on my computer, and with the microphone, we would be able to hear if counsel wants to observe as the video plays.
That, I mean, if that works, that would be fine. I don't know if anyone is working on the audio over there. It's just a speaker issue, or if not, that's however is best for you. I'm willing to give you guys 2 minutes or so to figure it out if you'd like.
So I guess, Alex, if I could invite you just to kind of view it.
I've seen it.
You've seen it. Okay, so, Your Honor, then I'll just try to get the volume going on my computer and have it close to the microphone. And let me just go back to that spot. It began at 6 something.
And Your Honor, I'm fine if they just want to proffer what the video is going to say, because the rules of evidence aren't adhered to. I'm fine with, just so we can move this along.
Right, and I appreciate that. I want them to, I mean, present it however they need to, so either way.
It's coming, Your Honor. Just 1 second. Okay.
So it sounds like it's, but it's not.
No, not at all.
Got it.
My wife Jody and I moved down here about 5 months ago.
Just say your name for the record,
Where's your
please.
speaker?
Jesse Schmidt.
Here, bring it up here. This mic's
My
louder.
wife and I moved down here about
Okay.
5 months ago, and we have
Okay. We're going to take it to that speaker. Okay, so we just need to back it up a little bit. Okay, wait, I gotta use the mouse, sorry. This computer's been
doesn't.
through a lot. Let's see, so. There.
If everyone would please log their votes on the computer, and the motion carries unanimously.
It's not letting us. He didn't push the second.
Well, I'm assuming that it's going to pass unanimously. Okay? We have these little computer glitches, okay. Next item is local achievements and, or no, I'm sorry, is public comment. And the
You can't
first
hear that,
person
can you?
to speak is Jesse Schmidt.
Barely. I mean, I can hear that there's something going on, but I can't really necessarily
So-
make
No
out
worries.
the
I
word.
also want to make
We
sure
can
the
just-
court reporter
I-
can hear it.
Take
Yeah.
a few minutes and then.
I'm
we'll-
just gonna give you guys a
we'll take-
couple minutes to see if tech, it looks like tech is working on it. I obviously don't wanna hold it up for too long, but you could also put on the record what the link is and where, and I can hear it here and we can proceed to. How long is it?
A few minutes.
Okay, I mean,
Well, the meeting itself is very long.
right, I know,
yeah.
but I
This
mean
testimony is not.
the portion of it. If you have the time, the beginning and end time stamps, I can listen to it.
I don't have those readily available. I
Okay.
can pull it up on mine. I believe my speakers are a lot louder,
It's okay.
if you don't mind me.
I'll give you just a couple minutes to sort it out and then decide how you want to do it, okay?
I think, Your Honor, it's our preference to go ahead and have the video shown.
Sure.
If we can.
If you can, if you want to work it out with tech too.
I'll go ahead and try this.
And, or no, I'm sorry, is public comment. And the first person to speak is Jesse Schmidt. Jesse, when you get up there, will you tell us how to?
I can hear her. In fact, I know who it is. I can recognize the voice. I know that it works.
I see. The microphone's not picking it up. I don't really know why.
Continue your presentation and come back to it?
I'd prefer to wait.
Is she able to get it on her computer? Madam Magistrate, do you have access to the internet?
I do, and that's why I said if you can't get it pulled up, you can tell me, I mean, you can put on the record the link and the start and stop time. I can listen to it, and then at least what would be on the record would not be the transcript of it, but it would be the location on the video, and it would be accessible.
I'm fine with that.
Is there an option for you to review it
Right now?
now?
Yes, yes, that's
That
an,
link?
yes, that's an option, but I would need the link.
Okay. Okay, so the link,
I could also bring my computer if there, you were not having trouble hearing from my speakers. I could bring it up to where you are, so perhaps the court reporter could also hear if there's no
If you
objection to
want,
that.
then council would, if he wants to approach, so everybody can hear it. That way, it's happening all at the same time. Would that be okay with you? That way, okay, so we can just
Thank
do
you,
it
Your
on
Honor,
the.
and I apologize, our normal tech person is,
I
Not today.
understand, it's okay. I understand tech issues happen, and if we bring it up here, maybe even we could use my mic. You can set it here, and you may be able to hear it then. Do you want to approach?
I've seen the video, I know what it says,
Oh.
I'm fine.
Okay, I mean, you might.
I see it on our computer screen as well, so I know what it is.
let me give it a try.
pronounce your last name properly? Is it Schmidt or Schmid?
Schmid?
Okay. So it sounds like a T, but it's not.
No, not at all.
I'm going to forward the presentation.
Jesse, just say your name for the record, will you?
Jesse Schmid.
Perfect.
My wife and I moved down here about 5 months ago, and we have 3 young sons.
It's
that-
echoing from a different speaker. Oh, because it is. It's coming from back there and I'm hearing it here too, right?
It's just this, it might be the audio quality of the video in that case.
Yeah, I am hearing it from both places.
Is
I'm
it?
hearing it there and here. Go ahead, try. I'll do my best.
They're 8, 5, and 3, and one of them goes to the beach school. And the weather is what brought us here. We've been coming here for around 20 years, and we have 2 boys that have Duchenne muscular dystrophy, so we needed nice weather. So we're down here, and we want to invest in the beach. So we've bought a couple houses already, and we're in the process of buying another one from Joe Orlandini. The house has some lien issues. It's kind of under a blanket umbrella regulations. And when all the other violations and liens are taken care of, there's around $50,000 left. And we would like to pledge that $50,000 towards his liens to get the blanket, get that house off of the liens if we could, please. So,
Is it, Jesse?
yes, that's it.
Okay.
Thank you.
I'll bring that up under my councilperson's items, Jesse. Thank you.
It would set a horrendous precedent that I don't think we should start with, and it will simplify matters a great deal if we all agree we're just out of the timeline. Okay, so there's a motion and a second.
Your Honor, just so everyone's aware, our regular tech person has he's connected remotely at this point, so they are working on the second and third video. So we may be able to actually use that, but the first video, they're not going to touch.
All those in favor, say aye. Aye. Okay. So now CE 180246.
I guess I would want to hear from staff if they have any.
That's the issue.
Roger and Jessica over there. Yes.
Agreement, we can craft it.
I don't know this couple at all, but I did hear.
Get close to the next one.
Plate, and they're trying to close on this property, and they'd like it to be released out from underneath the umbrella, period, of those liens. And I don't see why we wouldn't afford them that, or why we wouldn't accomplish that for him. It's not going to cost the town anything to do that, is it, Roger?
Well, the concept of the umbrella is that the wider we reach, the sooner we get paid. So narrowing our reach could impact us, but however, according to the notes that I was writing, that they were committing $50,000, if I understood them correctly.
That's correct.
Towards the lien bill, if you will.
That's right.
So subject to verification of everything they say, including their willingness to commit the $50,000 towards the overall lien bill, I would say that if all that bears out to be true and councils of agreement, we can craft an agreement that would pull them out of the umbrella and allow them to proceed.
Excellent.
If
Does
that's
anybody object-
council's
Does anybody object
direction.
to that? Were you gonna object to it, Joanne?
No, we want the liens paid.
Yeah, and
We
we want
want,
these
we
properties-
want properties to turn over. We want the best use of properties on the island. But we also want compliance. So we're not releasing the other liens, but I think that if this is one way to get this part done, let's get it done.
Yeah, I agree.
I apologize. I don't know why the volume changed suddenly.
Really. And if you can do well for the turtles as well, that's great. But you can't do for the turtles and sacrifice the people. That's my,
Okay, well. I'm going to see it.
What would you like?
I'm just going to proceed. One thing I want to point out, Your Honor, though, is that the council did mention in that hearing, we are not going to release all the liens. And that's really the part that I wanted to get out there. And I want to clarify that going before the council was necessary because both 1560 I Street, which is the property Mr. Schmid sought to release from under the umbrella of liens, and the subject property were both owned by Orlandini at the times the liens, including the subject lien, were recorded against the subject property. So pursuant to the face of these liens, as well as Florida statute, these liens encumbered all other real and personal property owned by Mr. Orlandini. And so when Mr. Orlandini is trying to sell a separate piece of property like 1560 I Street that doesn't have violations on it, that property needs to be released from under the umbrella of the liens encumbering his other property that does have violations, 80 Avenue E. So pursuant to this agreement, Jesse delivered a $50,000 check to the town to release 1560 I Street from the liens recorded against 80 Avenue E. This is my Exhibit 22. And I just want to note a couple of things on this check. Consistent with the minutes of the town council meeting on December 9th, 2019, the memo is partial release for 1560 I Street. The date is December 12th, 2019, so only 3 days after that meeting. And the amount is $50,000, which is the amount that they committed towards the amount of the liens on 80 Avenue E, not in satisfaction of those liens. Exhibit 23A is one of 3 partial releases that was recorded to release 1560 I Street from the liens on 80 Avenue E in exchange for $50,000. I just want to note a couple of things on the face of this release. Specifically, under the property owner's name, it says 1560 I Street. That's the property that's being released. The paragraph under that says, in accordance to the decision by Town Council on December 9th, 2019, to release the above-mentioned property from this lien for the amount of $50,000 has been satisfied in full, and that the undersigned hereby releases the lien as to the whole of the above-described real property and consents that the same be discharged of record. Under that is the really important part of this, which says, this partial release of lien releases only the property mentioned herein. All other properties attached as a result of instrument number 2019-000067-137 remain. And so that means that the liens encumbering 80 Avenue E remained. This release is only as to 1560 I Street. In February 2020, there was a town council meeting on February 3rd, 2020, and during public comment, Joe Orlandini asked whether he could mitigate liens for 80 Avenue E and one of his other properties, 1710 to 1740 Estero Boulevard. The minutes for this meeting are Exhibit 24. The relevant part is on page 9 under final public comment. And there, the council approved a motion to waive the rules regarding lien mitigation and allow the town manager and Orlandini to work out all of these issues Orlandini has pending with 1710 to 1740 Estero Boulevard and 80 Avenue E, which would have included the lien that we're here for today. Why this is important for today's hearing is that it shows that the check paid by Mr. Schmid to release 1560 I Street from the lien umbrella was not part of some broader settlement of all the liens on 80 Avenue E, or else Orlandini wouldn't have come to the council 2 months after that asking to be able to settle the liens on that property. This shows that as of February 3rd, 2020, there was no agreement in place to settle the liens on 80 Avenue E, including the one that we're seeking to foreclose today. Exhibit 26 is an email thread, and it's in reverse chronological order from the bottom of the page. And so the first email is from Mr. Schmid, dated Monday, March 23rd, and it says, "Hey Roger, this is Jesse. I was just wondering if we can set an appointment up this week where I can get Joe here and we can figure out the fines on his 80 Avenue E. I'm closing on it soon and I want to have everything addressed ASAP." Above that, you can see Roger Hernstead wrote, "We're working on defining all of the issues with this property. Please stand by." And you can see at the very top, Mr. Schmid responds, "Thanks, Roger. We're ready to close on this property. Would really like to get this figured out soon. Thanks, signed Jesse Schmid." And so again, this is important for this hearing because at this point in time, March 25th, 2020, so after the time that Jesse Schmid is now claiming he went to town council and came to an agreement to settle these liens, at this point in time, there's no dispute as to whether the code enforcement lien on the property that we're seeking to foreclose was still there. At this point in time, Jesse Schmid was aware that there are still fines and liens on the property, and he's actively trying to figure that out. The next day, before Mr. Orlandini, Mr. Schmid, and the former town manager met to discuss the liens on the subject property, a deed in lieu of foreclosure was executed from Orlandini to White Sand, dated March 26, 2020. However, this deed wasn't recorded until July 20th, 2020. On April 1st, Mr. Hernstead emailed Mr. Schmid and Mr. Orlandini explaining that 80 Avenue E has 2 code cases that are not in compliance and accruing fines at $250 per day, including the case we're here for today. So page 1 of Exhibit 28 is that same email thread we just looked at in Exhibit 26 with new replies. As you can see, it's the same email thread from the subject line, and it also has all the responses. And you can see that Mr. Hernstead, the former town manager, sent an internal email to Daphne Bircher with the town asking how long to unravel. And she tells him that she'll have something to him by 1. This shows that even after the deed was signed over to White Sand, town staff were still working out the information needed to discuss the fines with Mr. Schmid and Mr. Orlandini. Exhibit 28B shows that in response to Jesse's request on March 23rd, 2020, Daphne had prepared a summary of the status of the liens on 80 Avenue E and sent it to Mr. Hernstead. Which, as you can see from the exhibit, Mr. Hernstead forwarded to the email address Mr. Schmid had been emailing from, as well as Joseph Orlandini, saying, "Here are the fines to date, other conditions to follow," again indicating that there was not an agreement at this point. And if you look at Ms. Bircher's summary that Mr. Hernstead forwarded, you can see our case number CE 14-0394. A few lines under that, it says that it is not in compliance, no permits issued. And then a few lines under that, it shows the amount due under the lien at that point in time, which was $367,150, now owed with $250 per day being imposed until compliance. Again, showing as of April 1st, 2020, the liens were still on the property, fines were still accruing, and Mr. Schmid was aware of that. Exhibit 29 shows that after no response to the lien status update on April 1st, 2020, Roger followed up on April 1st, 2020, or April 9th, 2020, and Orlandini had asked to speak with Mr. Hernstead privately. And then there's something that's not in this timeline, but is relevant to what the respondent is claiming. On April 16th, 2020, a mutual release of claims was recorded pertaining to the beachfront property located at 1710 to 1740 Estero Boulevard. And I can provide a copy of this exhibit to you as well as Respondents Council, and I would mark this as the town's Exhibit 54. If I may approach.
Any objection, counsel? No objection, okay. You're seeking to admit this Exhibit 54?
I'm sorry, Your Honor?
I said, you're seeking to admit Exhibit 54?
Yes, Your Honor.
Okay, it'll be admitted.
So in paragraph 16 of Respondent's affidavit, he states 5 days later on March 31st, 2020, Beachfront Escapes wrote the town a check for $111,628.04. Under that, in paragraph 17, a copy of the check is attached. And then in paragraph 18, it states Beachfront Escapes issued the check to the town to pay the remaining $15,000 owed by Orlandini under the purported agreement, as well as to pay the town for fines related to Mojo's. And so what I've just given you is a mutual release of claims. Thank you. Between the town of Fort Myers Beach and Beachfront Escapes LLC. And a couple things I want to point out. The first whereas clause describes certain property located at 1710 to 1740 Estero Boulevard. This is the subject property of this release. This defines the subject property. The second whereas clause identifies the case numbers that this release relates to. Notably, our case number, the case number we're here for today, is not included in this release. And then under the paragraph where it says now, therefore, the first numbered paragraph, it states, Beachfront shall, on or before March 31st, 2020, pay and deliver to the town the sum of $111,628.04. And that's the amount of the check that Respondent is claiming also covered the $15,000 owed by Orlandini under the agreement. And I just want to note that the entire amount of this check is accounted for in the mutual release of claims. There's no mention in this mutual release of claims about anything to do with 80 Avenue E or the instant case. The amounts are identical. And so there's nowhere where this extra $15,000 could have come from to account for whatever this purported extra $15,000 that Orlandini was supposed to pay was going to come from. The check that they've attached represents solely a payment made in furtherance of this mutual release of claims pertaining to a completely separate piece of property. And so that check is not relevant to this case, and it does not show that there's any sort of settlement agreement pertaining to this particular case or this particular property. I'm going to move on to November 2020, Exhibit 33A. And at this time, Paula Kiker, a realtor, sent Daphne Bircher with the town of Fort Myers Beach an agenda for their Jesse Schmid meeting to discuss the status of Mr. Schmidt's permits and fines on 80 Avenue E. Again, I'm looking at Exhibit 33A. You can see from the signature block that the sender is a real estate broker. At the top, the subject line is agenda for Jesse Schmid meeting. And a couple lines below, you can see the attachment is agenda for Jesse Schmid. The next page, Exhibit 33B, is that attachment, and you can see on there that the third entry is 80 Avenue E, fines on 80 Avenue E. So again, at this point in time, November 2020, after that mutual release, after the check that they're claiming should have settled this, they're still trying to work out the issues on 80 Avenue E. There's not an agreement in place. The next page, page 3, is labeled as 33C, and this is Ms. Bircher's response to Ms. Kiker's email. You can see at the top that Ms. Bircher also copied Mr. Schmidt in this response at sales@schmidtiesmachinery.com. I have documents establishing that this is Mr. Schmidt's email address. If there's any objection to that, I'll just present those in a moment. But you can see from the subject line, this is the same conversation. Going to the next page of Exhibit 33C, towards the bottom, you can see Daphne's response to the inquiry about 80 Avenue E, and she, as town staff, says, when Mr. Schmidt acquired this property, the town manager quoted a settlement for the outstanding liens. In accordance to the compliant agreement sent to Mr. Schmidt on May 1st, 2020, a one-time fine of $61,628.04 was due immediately. Additionally, in order to release the lien, all permits were to be applied for and issued by July 1st, 2020, and a certificate of completion was supposed to be issued December 31st. Mr. Schmidt has not paid the settlement offered as of this date, and no permits have been applied for. Roger told me that the new reduced fine is $75,000. That fine needs to be paid, and the violations need to come into compliance in order to release the lien. So here at this point, we are still in the stage of negotiating an agreement. This shows that there was no agreement up to this point in time. The documents are further going to show that there never was an agreement that was actually settled on. Okay, so going now to page 9, which is marked as 33D, shows Ms. Kiker's response. And you can see again that Ms. Kiker has copied Mr. Schmidt on the communication at sales@schmidtiesmachinery.com. And she acknowledges Ms. Bircher's email and states that I've been working with Jesse, meaning Mr. Schmidt, to get everything back on track. Page 16 is marked as Exhibit 33E and is another email from Ms. Kiker to the same chain dated November 3rd, 2020. Again, you can see Jesse's copied on the email, and she says, this is page 16. Thanks for the call and further clarifications. I've added Jesse's contractor, Steve Sutter, to this email chain so everybody is on the same page of what needs to be done by all parties in order to get this cleaned up. My clarifications are in red. Please let us know if we can set up a meeting for the 80 Avenue questions. At the bottom of page 19 and at the top of page 20, you can see Ms. Kiker's comments regarding the 80 Avenue E comments in red, as she mentioned. And so those comments state, and this is at the bottom of page 19 again, Jesse understands if he demos the home, the outstanding code violations go away and fee needs to be paid no matter what, but would like to have a meeting with the parties that be to see what can be built back should he decide to go that route. Should he decide to keep, we understand that Steve Sutter needs to apply for an after-the-fact building permit for all the work that has been done and has the option to hire a third-party engineer to state that all of the work to date is, quote, in compliance. The home must be in compliance before the lien will be removed. Again, Mr. Schmidt is copied on this email. He never offers any objection or clarification, so he ratifies the statement or his state of mind as represented by his realtor in his presence. This shows that Mr. Schmidt's knowledge that the property remains out of compliance as of November 2020, that he will need permits to bring the property into compliance, and that the property must be in compliance before the lien on the property will be removed. Moving now to page 25, which is marked as Exhibit 33F. You can see at the bottom where Ms. Bircher responds to Ms. Kiker's statements regarding 80 Avenue E and Jesse's plans to correct the violations on it, saying, the information requested can be obtained through a zoning verification letter, link provided for zoning verification letter below. The fee for the zoning verification letter is $250. Then she provides the link. And again, at the top, you can see that Ms. Kiker responds that she will follow up with Mr. Schmidt the next day. And again, you can see at the top where he's copied at sales@schmidtiesmachinery.com. Exhibit 34 you can see that Jesse Schmid paid for a zoning verification letter on 80 Avenue E. This is, you can see on this receipt, it says date 11/5/2020. So this was 2 or 3 days after Daphne Bircher with the town suggested that he get a zoning verification letter to see what could be built back on the property if he decides to take care of the code enforcement violations by demolishing the property. Consistent with what Ms. Bircher sent in the email, the total for that is $250. And again, you can see on this payment verification, it is for a zoning verification letter, and at the top it says address 80 Avenue E. This shows that Mr. Schmid followed Daphne's suggestion to obtain a zoning verification letter, again, to determine what could be built back if he chose to correct the violations by demolishing the property. This shows us that the reason for the zoning verification letter was requested was to see what could be built back if Jesse Schmid decided to remedy the violations by demolishing the property. It also shows that Mr. Schmid was actively involved in the conversation between Ms. Kiker and Ms. Bircher, because that conversation concluded with Ms. Bircher suggesting that Mr. Schmid obtain this ZVL. The next exhibit is Exhibit 35. This is a copy of the zoning verification letter that was issued to Mr. Schmid. This is also the same zoning verification letter that respondent is now claiming suggests that there are no further code enforcement violations on the property, and that if anything else, this date, November 18th, 2020, should mark the date of compliance. I just want to note a couple of things about this. This was issued November 18th, 2020. The last line of this letter says, this letter is responsive to the zoning verification application submitted November 5th, 2020. So again, this was issued pursuant to that payment receipt that I showed you in Exhibit 34, which in turn was submitted because Daphne Bircher suggested that Mr. Schmid obtain this letter to see what could be built back if he decides to remedy the code enforcement violations by demolishing the property. And so the suggestion that the fact that this letter says there are no code enforcement cases on this property somehow means that there's no liens on the property, no violations, is somewhat ridiculous given the context of why this letter was obtained. It's clear from the context that this isn't the case because, again, the whole reason that he asked for this letter was to see what could be built back to correct the violations. And then a couple other things on the point that respondent is trying to make, that there are no active code enforcement cases on this property. I have a couple other documents to show that just because this letter says that doesn't mean that there are no code enforcement liens or violations ongoing. Thank you.
See you in the magistrate.
Yes, thank you. Okay. So the exhibit I'm providing, I'm marking as the town's Exhibit 55. This is a lien search request form requested on behalf of White Sand Properties of Fort Myers Beach. The date of the request is January 27th, 2020. And at the bottom, you can see where it says staff use only, which is what was filled out by town staff, and it says code enforcement liens, and the box checked says see attached list. Pending code enforcement cases, none. And so this shows that the town can say there are no pending code enforcement cases, but that doesn't mean that there's not existing code enforcement liens. This document shows that even though this document says no pending code enforcement cases, it also clearly attaches the same code enforcement lien that we're seeking to foreclose today. So fast forwarding now to December 12th, 2021, at a management and planning meeting, the council requested that a discussion regarding collecting fines be added to the next management and planning meeting agenda. This is reflected on page 3 of Exhibit 38, which are the minutes from that meeting. I also reviewed the video from this meeting, and the context of this was that a council member had previously asked the former town attorney for a list of properties with the largest code enforcement fines and wanted to discuss whether the council needed to take some sort of procedural action or legal action against these properties. The next day, after that MMP meeting, Patty Prevost with the town prepared and sent Ms. Bircher a lien list as of December 9th, 2021, which lists the status of the liens on 80 Avenue E, including the status of the lien that we're currently seeking authorization to foreclose today. And so Exhibit 39A is a copy of that email, which at the top shows an attachment named Lien List 12-921. And then the next page, marked as Exhibit 39B, is a copy of that attachment. And you can see from the first line, it shows that the code enforcement lien we're seeking to foreclose is included still as of December 9th, 2021, and it shows the amount due and says that it is still accruing at $250 per day, again showing that at this point in time the property was not considered in compliance. It also shows that the lien still existed on the subject property. And then at the January 13th, 2021 management and planning meeting, former town manager Roger Hernstead reported that there were some code enforcement cases with large liens and the property owners were not cooperating with the town to resolve these violations. The vice mayor asked the former town attorney to provide a list of violators at the next council meeting. Exhibit 40 is a copy of the minutes from that meeting. This conversation begins on page 2, paragraph C. And I'll just read a couple sentences from that. So the first sentence says, town manager Hernstead reported that there were some cases with large liens and the property owners were not cooperating with the town to resolve their violations. Councilmember Allers commented that a violator could pay their accrued fees without collecting the violation or correcting the violation. Town attorney Herron replied that daily fees would continue to accrue if the property owner paid the fines without coming into compliance. This emphasizes the importance of coming into compliance before any sort of settlement is reached. Vice Mayor Hosfrost suggested that the town attorney provide a list of violators during the attorney's items at town council meetings, and then skipping forward a couple more sentences. Vice Mayor Hosfrost suggested providing a list of violators over 90 days and another over 6 months. Town attorney Herron Jr. agreed to provide. After that, the next council meeting was January 24th, 2022. And at that meeting, the former town attorney provided a list of 14 code enforcement liens, including the lien that we're seeking to foreclose today, and noted that there were only 2 options to bring the properties into compliance: foreclosure or injunction. The town manager indicated that the property owners on this list were the ones they were unable to work things out with. Town council reached a consensus to move forward with title searches for foreclosure of these liens. So Exhibit 41A is a copy of the minutes from that meeting, as well as Exhibit 41B, numbered as page 10, which lists 14 code enforcement liens and was included as the agenda materials for this meeting. This list appears on the last page of composite Exhibit 41, labeled as 41B, and you can see this is essentially the same list that had been prepared by town staff the previous year in December 2021, showing that the lien in our code enforcement case was still encumbering the property. At this point, $514,150 had accrued and was owed on the lien, and that it was still accruing at $250 per day as of, what is this, January 2022. This list was discussed again at the April 7th, 2022 MMP meeting. Those minutes are Exhibit 42. And then on April 18th, 2022, the town council unanimously approved a motion to authorize the town attorney to enforce the code enforcement violations and liens in Attachment A through court actions, including foreclosure. And Exhibit 43A is the minutes from this hearing. Page 15, marked as Exhibit 43B, is the agenda item summary, which shows that there was an Attachment A subject, that was the subject of that motion. And then page 16, marked as Exhibit 43C, is the memo referred to in the minutes as Attachment A. And on the last page of that, you can see the subject property appears, and the liens on that property are referenced. Moving now to Exhibit 44A. And this is an email exchange in reverse chronological order between former town attorney John Herron and Daphne Bircher with the town. This email is related to apparently Mr. Schmidt had reached out to the town council member Adderholt, and so Mr. Adderholt had reached out to John Herron for information on what Jesse was asking about. And this, I believe, is referenced in the respondent's affidavit. Although perhaps this is early. Regardless, the second paragraph of this email, Mr. Herron states, "Please correct me if I'm wrong, but isn't this the property that was originally owned by Joe Orlandini, for which he was cited by code enforcement staff for doing work without a permit? Thereafter, because Orlandini took no action to bring the property into compliance, his case was brought before the town's code enforcement special magistrate, who found Orlandini to be in violation of the code, and due to noncompliance with the special magistrate's order, a lien was placed on the property. As I recall, somewhere in between or shortly after the recording of that lien, Jesse Schmid/White Sand acquired the property, in bold, with full knowledge of the code violations and lien, in bold, for a discounted price. Neither Orlandini nor Jesse Schmid/White Sand have ever applied for a building permit, yet the property is being actively leased out. Am I correct?" And then you can see at the top where Ms. Bircher responds, the second paragraph, she says, "You're correct with your synopsis of 80 Avenue E." And then below that, she says, "Additionally, Roger has offered to work with Mr. Schmid several times, but Mr. Schmid has never followed through." And this, again, is being offered to show that as of May 16th, 2022, the town's position was there was no agreement still. The liens were still on the property. On August 12th, 2022, a foreclosure complaint was filed by John Herron. And again, we went through the date of compliance, which was deemed to be September 2022, because the property was demolished by Hurricane Ian. And again, that's Composite Exhibit 45. And that pretty much brings us to the present day. To supplement this timeline, I have a couple of affidavits from the town records custodian. Exhibit 52 is being offered to show that no agreement exists. I'm not going to read the whole affidavit, but I will read paragraph 4, which states, "I certify there is no entry in the public records of the town or any of the following to the best of my knowledge. A fully executed written agreement to satisfy and release the code enforcement lien recorded against the property located at 80 Avenue E, Fort Myers Beach, Florida, 33931 in code enforcement case number 14-0394. A fully executed written agreement between the town of Fort Myers Beach and Jesse Schmid to satisfy and release the code enforcement lien recorded against the property located at 80 Avenue E in case number CE 14-0394. A fully executed written agreement between the town of Fort Myers Beach and Joseph Orlandini to satisfy and release the code enforcement lien recorded against the property located at 80 Avenue E in case number CE 14-0394. A fully executed written settlement agreement between the town of Fort Myers Beach and White Sand Properties of Fort Myers Beach, LLC, to satisfy and release the code enforcement lien recorded against the property located at 80 Avenue E in case number 14-0394, or payment made to satisfy and release the code enforcement lien recorded against 80 Avenue E in code enforcement case number CE 14-094. Exhibit 53 is an affidavit that is being offered to show that the emails and attachments that I presented are public records of the town. And then as to those emails, For documentation as to Jesse Schmidt's email address, I have a couple of exhibits. What?
Did you talk about the reduction hearing? No. Okay.
And I've marked this as the town's Exhibit 56. This is a Town of Fort Myers Beach driveway application. You can see that the applicant is Jesse Schmid and Jody Hannon. And on this application, the email listed is sales@schmidtymachinery.com, which is the same email address that was copied on the email correspondence between town staff and Paula Kiker. There's also a signed certification at the bottom that, to the best of my knowledge, the information submitted for this permit is true and correct. And so that's being offered in support of Jesse Schmidt's email address.
Council, any objection to Exhibit 56?
Not to Exhibit 56, but I do have a question. Council referenced August of 2022 foreclosure action. I don't see that in the exhibits.
I was just referencing that as a milestone marker. That's not evidence that I'm presenting.
Okay, I thought I heard you say it was in your
I-
exhibits. I apologize. I just wanted to be clear.
No worries.
Okay,
Anyways.
No objection to Exhibit 56? Okay, thank you, it'll be admitted.
All of it, what I've just presented, today being said, what we're here today, again, is really very simple. We're just here requesting authorization to foreclose the lien recorded in code enforcement case number 14-0394, which, once again, has been marked as Exhibit 19. Again, the statutory prerequisites for foreclosure of a code enforcement lien are set forth in Section 162.09 sub 3, and the town has met those requirements. It's clear on the face of the lien that it has been more than 3 months since this lien was recorded, because it was recorded on March 27th, 2019. It's also clear that the lien remains unpaid, as evidenced by the timeline of documents I just presented of the proceedings, showing that the lien has never been settled, paid, or released. The affidavit of compliance marked as 45A, and the affidavit of code enforcement manager marked as Exhibit 4. In addition, counsel's own arguments suggesting that there may be a credit owed on the lien, but even if such a credit was applied, there would still be an amount outstanding on the lien. Accordingly, the evidence shows that, again, the statutory prerequisites have been met, and we again respectfully request that Your Honor enter an order authorizing the town to foreclose on the code enforcement lien recorded as instrument number ending in 7137 in the incident code enforcement case. Thank you, Your Honor.
Thank you. Okay, this case is simply a request from the town allowing them to file a foreclosure action in circuit court. Essentially, my job is to review what the elements are and whether they've been met. There's no question respondent's the owner. This is not a homesteaded property. Notice, service, all of that has been met. As far as there being violation on the property, fines were assessed and a lien was recorded, that has obviously been met. Whether the fines or liens have been paid, it is clear that they have not been paid in full. There is a question about the partial release for the $50,000. Now, the partial release was on the property 1560 I Street. But the lien ending in 7137, by virtue of it being a lien, encumbers all the properties by that owner. And so it did include 80 Avenue E. I'm going to ask the parties a couple of questions to help clarify something, to see whether and to what extent any part of this $50,000 could be applied towards this lien. I'll ask respondents' counsel, I suppose, first, and then I'll ask you. How many properties was instrument ending in 7137 encumbering at that time?
Yeah, those are all Mr. Orlandini's properties, and
How many properties were being encumbered?
you would think at least 5 is what we're suspecting.
Okay, then I'll allow the town to answer that. Do you know how many towns were being encumbered by that lien 7137?
My response would be a guess, and it would be aligned with what Respondents' Counsel is saying. I believe it's approximately 5 properties. Those properties did not include the properties owned by Mr. Orlandini's business, Beachfront Escapes, because that is a separate owner of record. And so it would be the properties owned by Mr. Orlandini, not the property owned by Mr. Orlandini's business, Beachfront Property, or Beachfront Escapes. And I believe that's the 1710 to 1740 Estero, and so that property would not have been encumbered by the liens on 80 Avenue E. And so to the extent there are other properties like that where Orlandini's business owned it, that's a separate owner of record, and it would just be the properties owned by Mr. Orlandini in name. I believe that that's approximately 5 properties, but I can't say for certain.
So, Your Honor, Beachfront Escapes is Lyle Klein, and when you actually look at the check from Beachfront Escapes, you'll see Lyle Klein under that LLC. So the Mojo 1710, 1740 was Beachfront Escapes and Joseph Orlandini, just like I believe I Street was the Lyle Klein Trust and Joseph Orlandini individually. But I'm happy to work with counsel to get verification on the exact number of properties.
How many, okay. So the 50,000 was to partially release each of the liens on 5060 I Street?
So, Your Honor, I Street did not have any code enforcement liens.
Okay.
It was only encumbered by virtue of the liens on 80 Avenue E. Does that,
Was it only encumbered by the lien on 80 Avenue E, or was it encumbered by liens on other properties as well?
just 80 Avenue E? Because the ownerships were different in terms of how I Street worked.
And
So,
how many liens was that?
well,
3, Your Honor.
3.
Well, 2. 3 instruments were released, 2 code enforcement cases.
Okay, so the 50,000 was to partially release each of the liens on 5060, I'm sorry, on 1560 I Street. Was that 3 or 2?
It's 2 liens. However, what I believe was an abundance of caution. There were 3 releases recorded. 2 of those releases were in the same code enforcement case. It was the code enforcement order imposing lien, and then a previous order in that case had been recorded as well. And so 2 releases were filed, and I actually have those releases in my packet. Can I have the index? That's Exhibit 23. So Exhibit 23 represents all of the releases that were recorded to release 1560 I Street from the liens encumbering 80 Avenue E.
I guess my question is, the 50,000 was towards how many? Was it towards, payment towards 3?
It was payment towards 2.
2, okay. As for the argument that your first argument, respondent, that they initially sought to foreclose a different instrument, and that res judicata would apply, or that they've elected a remedy. I do not agree with that. We had a hearing about a year ago, and your argument specifically was that it was not a clerical error, because the town had sought to foreclose on a completely different instrument, and therefore it had to be renoticed as such. And I agreed, and that's why we're here today, because it is specifically another instrument. There was no foreclosure requested on this instrument at all. So I do agree with the town that that does not bar seeking foreclosure. It is a completely different instrument. So as far as, do the materials have the information on those other liens that were being released from the 50,000?
Yes, Your Honor. Each of those releases indicates at the bottom that they're being
Do we have?
in accordance to the decision. I'm sorry, Your Honor.
Do we have information on how much those liens were for?
I can tell you.
Because if there's a pro rata application of the 50,000 towards everything that was owed, that would be important information.
So the two liens that were released were the lien that we're here for today, and the amount owed is, without accounting for that $50,000, is the amount that I've stated. The other lien in code enforcement case number 17-0065, that lien is for only $500.
And, Your Honor, my point to that would be, they've already received authorization to foreclose on that in full. So there's no real pro rata set off on that, given how they've already gotten the authorization to go on that in full. So it should all be applied in this case.
And Your Honor, I just want to proffer that we agree that Mr. Schmid went to the town council requesting to pay $50,000 towards the liens on the property. And so in our foreclosure suit, we are requesting that that $50,000 be credited to the total amount owed.
Your Honor,
That answers my question. Thank you.
Your Honor, they filed an actual count to foreclose on that. If that position is correct, to credit the $50,000 as to that lien amount in that case, the 17,065, they can't foreclose on it because it's been paid in full. $500
Your Honor, I
is
object.
considerably less than $50,000.
That's not the case before me.
But my point is that they're trying to get a double credit on this lien and the other one, and it's inconsistent.
That's not what I'm hearing. I believe the town just said that they would seek to credit the 50,000.
But they're
We
foreclosing on it.
acknowledge that we're foreclosing on a lien that is $500, which is obviously less than $50,000. Our position on that is just to keep everything straight. But we're not going to file a release of that lien and then credit $49,500 to. We're just trying to take care of it all at once. But that $50,000 is to be credited to the respondent towards the code enforcement liens on the property, which, to whatever proportion, includes the lien that we're here for today.
The purpose of my questions is to figure out how much to credit, if to credit. And what I'm hearing from the town is that they don't have an objection to the crediting of that $50,000,
And for today.
which is what's before me.
Well, I'm just making sure because they, as I understood what they were saying, is they were trying to say we're trying to give that credit in the foreclosure case and somehow reduce it by $500 here today.
I don't hear that. That's not what I'm hearing from
Okay,
the
so
town.
then the other thing I need to bring up to Your Honor is if you're disagreeing with my election of remedy argument, and agreeing with their position, which is essentially it's a different instrument, even though it's the same code violation, the numbers still don't work out because that new instrument is recorded on March 27th, 2019. Even if you take their compliance date of Hurricane Ian, that comes up with $320,250, not the $500,000 number they're seeking permission to foreclose on.
I think that they've added what was on there and the $250 a day thereafter,
No, they said the
Yes,
date
Your
of
Honor.
compliance was Hurricane Ian.
which was September 28, 2022.
Yeah, so from March 27, 2019 to September 28, 2022, that's 1,281 days at $250 a day, gets you $320,250.
Plus the amount that was on the lien that was recorded.
That was vacated, and they're saying it's a different
That was not
instrument.
that was not vacated. What was vacated was the previous lien. This lien had an amount on it, which was, what, 200, could you give me the?
Yes, I can read directly from
It's-
the order.
It's okay if you want to give me the exhibit number.
It's Exhibit 19.
Thank you.
But that's the point, Judge, is that if you accept their entire framework of this, is that it's a different instrument, and it's either one or the other, so.
Counsel,
That's our position. I just want the record made clear for us.
I understand. The lien that they're seeking to the lien that they're seeking to foreclose on, the instrument 7137, when it was recorded, it was an amount of $257,150 at that time, plus $250 per day thereafter. What they're saying is your number, which was the 320,000 figure approximately, is then added to this number because this was the number from that time forward. This is not the one that was vacated. The one that was vacated had a different number on it, and this one replaced it. Then you add $250 a day for that after that until September 28, 2022, and that's how they got to the number.
No, I understand that. I just disagree with that contention.
Okay.
And that's what I wanted to make clear for the record, is that they can't double dip on a vacated lien.
That's not the vacated lien. The vacated lien was, do you have that exhibit number?
Exhibit 19.
That's exhibit 19?
Oh, I'm sorry, the vacated lien. That's to the index. That is Exhibit 11.
The vacated lien was, I don't have the instrument number on that.
I apologize, Exhibit 13. It's Exhibit 13.
Got it. Okay, the vacated lien was instrument ending in 6125. The number on that, the amount on that was, there wasn't an amount on it. That's probably why it was vacated. There was no actual amount on it. That's a different instrument. So that one is instrument number 6125,
Yes, Your Honor.
and it just had $250 a day from that point forward. The one that was recorded in 2019 had the amount that was accrued from the violation, from the original date of the violation, up until the date that it was recorded as a lien, and then continued to accrue thereafter. That one that was recorded was not vacated. Is that what
Yes,
we're
Your Honor.
alleging here? Thank you. The next question that I had was pursuant to costs, besides the amount that the fines had accrued on the lien, do you have any additional items such as costs that are added that you're seeking in the foreclosure, and if so, documentation towards that.
No, Your Honor, just what's stated in the affidavit of compliance and then the code enforcement officer's affidavit as Exhibit 4.
Okay, thank you.
This doesn't preclude, what I'm saying doesn't preclude what our request would be, which would be for whatever we're statutorily entitled to under foreclosure. So attorneys in the foreclosure action in circuit court, which would be attorneys' fees.
In the foreclosure action, yes. I'm talking about within the lien because it does have, that was recorded, there's $150 cost assessed, and then any additional costs before you get to the circuit court. Obviously, I can't tell you what you're entitled to in circuit court.
Yes, Your Honor. At this point in time, that's such a
Okay.
fluid number.
All I have is the 150 that was
Yes,
on
Your
the lien
Honor.
that was recorded. Okay. Okay, I would like to take a quick break, 10 minutes, if that's okay, or it could be 8 minutes to 11:25. I just want to review a couple of items
Yes, Your Honor.
that were submitted today that I didn't get to review. Okay, I know respondent submitted an entire binder. I've not had an opportunity to do that, so I want to do that right now, okay? All right, so 11:25. Okay, thank you. We're back. Okay, I was reviewing respondents' materials because I wanted to make sure any further questions I had I could address here today. And I would like to direct the parties to Respondents Exhibit 1F and G. These appear to be partial releases also of the lien that are separate from the $50,000 that was recorded, the partial lien, that was paid the year before this. These were partial releases of lien for the same instrument number. For the town, what was the consideration paid for these partial releases? Is your mic on?
Your Honor, it doesn't state on the face of the release, and so
Have you seen these before?
I have seen these before, Your Honor, yes.
You don't know what they're for?
I don't know what they're for.
Okay.
I know that this is regarding Mr. Orlandini, and I know that this happened in March 2021. As far as I've been able to determine, I've gone through all of the records of the town that I've been able to get my hands on. All I can say about this is that it's not related to anything that Mr. Schmid came before the town council for. I have knowledge based on trial transcript testimony from Mr. Schmid testifying he sued Mr. Orlandini, and I know in that, and I'm not proffering this as evidence, just there had been in the past, I think, intentions for Mr. Schmid to buy more properties, and bottom line is I don't know what the consideration, if any, there was for this partial release of lien. But it appears this was recorded after Mr. Schmid already owned the subject property, and I can say with certainty that this has nothing to do with the town council meeting that occurred in December 2019.
Okay, responded.
The consideration is that set forth in the affidavit that was part of the overall agreement that we're contending existed to resolve the liens as it concerned 80 Avenue E, which was the $50,000 plus the extra money that was paid
Yeah, I know. I took it out.
when when White Sand closed on the 1710, 1740 Mojo's property.
How much was that extra money?
That was the extra $15,000. That was part of the overarching $65,000, which you had actually heard evidence earlier about how Mr. Hernstead had offered to resolve all the liens for somewhere in, I think it was like 60, 65, somewhere in that $60,000 range.
The additional 15,000 was for how many liens?
It was all the liens were to be paid and resolved for $65,000 as it concerned 80 Avenue E. So everything that was encumbered as an ancillary property because of 80 Avenue E's liens were encompassed within that $65,000. They did not include code enforcement liens that may have existed on those properties independent of 80 Avenue E, though.
Right, it was to release those properties from being encumbered from this particular lien. My question was how many was that 15,000 to be applied to?
The same as the 50,000. It was all for
Okay.
all the same properties as we identified in the affidavit.
Your Honor, I just want to clarify, the release as to 455 Palermo, I do have an email from Orlandini. I don't have it printed out. To suggest that this was a completely separate agreement again, that had nothing to do with Mr. Schmid. Regardless, though, there only evidence of this $65,000 agreement is Jesse Schmidt's testimony. There's no documentation supporting this whatsoever. This instrument, the releases that are in this file don't say anything about $65,000, $50,000, or otherwise. And so it's my position that they have not presented evidence of any agreement whatsoever. And I just wanted to make that clear.
I'm just trying to clarify what he's given us, or what,
I
I'm sorry, what
understand, Your
he's
Honor.
submitted and what he's saying, everything, what he's
Yes, Your
saying
Honor.
represents. So my next question is, do you have, I know you have the $50,000 check. Do you have the $15,000 check or receipt for the payment?
Yeah, that's, well, that's I think, a factual dispute that we have with the town, but the position of White Sand through Mr. Schmidt was that the money that we have the check for, which is the check made out from Beachfront Escapes, was wrapping up into that $15,000, or that $15,000 was included in that amount. But that check is part of the affidavit.
Okay, thank you.
And Your Honor, the only other part that I could say could aid you in that analysis is we have the settlement statement for the 1710, 1740. Given that Mr. Orlandini was an owner of that property, seemingly if the 80 Avenue lien was encumbering it by virtue of his ownership, it would have been included on that closing statement. Our position is that because the check was made out to the town before then, that those liens that we're talking about were resolved.
Release.
Yes, ma'am.
May I
I'm
respond to that, or?
Sure.
I just want to note again, the partial release that I showed was between a business entity and the town, not between Orlandini and the town. And so the sale of that property, whatever closing statements, the 80 Avenue E liens wouldn't have shown up because
I'm sorry, I didn't hear.
I don't know why my mic isn't working. I apologize. I'm just going to grab this one.
Yes, that's fine. You can use.
The release agreement that I provided concerning the Estero, the Mojo's property, 1740, that agreement, which the check was made pursuant to, was an agreement between the town and a business entity, not the town and Mr. Orlandini. And so the closing documents for that property would not have reflected the 80 Avenue E liens because those liens encumbered all properties owned by Mr. Orlandini, not all properties owned by that business entity.
I understand. I understand the argument. Thank you. Okay. I want to take everything back with me and review everything in greater detail to be fair to all of the parties. I have spent time already reviewing the towns before today's hearing. The context of the hearing was helpful, and the town has submitted additional documents that I would like to review, as well as spend an equal amount of time reviewing everything that respondent has. I have taken a look at it, but to be fair to all the parties, I want to do that before I do issue a ruling. I have I think, a very good understanding of the positions of both parties, and I'll be prepared to issue an order with the findings of fact. And conclusions of law. I would be happy to accept proposed orders from the parties. I do not anticipate that you would be able to agree on a proposed order, and I've not given you enough information on how I will rule for you to be able to do that. But if you would like to do that, you can submit proposed orders, I would say 1 week from today, no later. And I would be happy to review them, adopt and revise, however, or not, right? So do exchange them before you provide them, please, but I don't anticipate you're going to have an agreed order. So that's it. I think I have asked all the questions that I just wanted clarified on the materials that I've reviewed. Does anybody have anything else to add in closing?
No, Your Honor.
Okay. All right, then we can adjourn, and if I could find this, and we are adjourned. Thank you.
Thank you.